good afternoon, and welcome to our webinar series, Top Estate Planning Pitfalls Advisors Should Help Clients Avoid. Thanks so much for joining us. I want to mention a couple of upcoming chapter events. We've got a webinar series exploring charitable options for your clients on June 3rd from 12 to 1. Webinar series Ethics, a practical application of CFP Board's code and standards on July 29th from 12 to 2. That will get you your required ethics CFP credit for 2026. A webinar series, Rethinking Loan Qualification, the Power of Non-Agency Lending Solutions on August 19th from 12 to 1 p.m. Check our website for details, updates, and register now. We are thrilled to be joined today by Mark Brandenburg, who has over 20 years of experience in estate planning, estate administration, and probate law. Before we dive in, please use the Q&A feature at the bottom of your Zoom screen to share questions or comments throughout the session. We want this to be interactive and valuable for you, and Mark will address those at the conclusion of his presentation. And with that, I'll turn it over to Mark to begin.
Good afternoon, everyone. Thank you, Kathy, for that nice introduction. And thank you, all of you participants who are joining us today to learn a little bit about estate planning pitfalls and how you as financial advisors can help your clients avoid them. What I want to cover today is I want to first go over why estate planning can fail. We're going to talk about some reasons why estate plans fail. Then we're going to launch into the top estate planning pitfalls. I have 10 of them that I've curated. Many are based on personal experiences I've had in my practice, and I'll highlight those for you. And then I want to conclude with 3 key takeaways for you to walk away from this presentation with. And at the end, I will be happy if there's time to take questions that you may have. So let's dive into the case study of the family I'm going to call the Adams family. The Adams family are a real family. I'm just using a fake name in a matter that I have been involved with, where the husband and wife were married in the 1950s, and they had 4 children. And when they did, they created mirror image wills in the 1960s to accommodate for the event of death or incapacity. So they had wills, they had powers of attorney, they had all the things that would be sort of typical for a family. In the wills, it said, upon my death, it all goes to my spouse, and the remainder goes to my 4 children equally. That's about as simple of an estate plan as and common of an estate plan that we can design. They then sat on that estate plan and didn't make any changes to the documents until they both died in the 2020s. What happened in the interim from the 60s to the 20s is that they raised a completely dysfunctional family. Where by the 2020s, husband and wife were not living with each other and were separated from each other. The 4 children couldn't get along with each other, and they broke up into 2 camps, 2 on one side and 2 on the other. One of the children has mental health issues, and potentially all of them, or many of them, have other substance abuse issues. But they did not change their estate plan. When they did decide to change their estate plan, it was the husband. He updated his estate plan in 2020 by going to a lawyer and putting into place a revocable living trust. The details, though, were that he was at the end of his life, and there's some question about whether the child who took him to that meeting had unduly influenced him. Reason being that his estate plan at that time didn't give anything to his spouse and gave everything to his children, but not in equal shares. And created trusts for some of the children, but not all of the children. To add to the complexity of the Adams family, they also owned real estate in 4 states. Some of that real estate was rented. Some was occupied by family members who were not paying rent. Some was farmland. Some was one item was a fully operational apartment building, all with their own complexities. The wife never got a chance to update her estate plan before she died. So husband and wife both are deceased now, and what they've left behind is a failing estate plan. Why do estate plans fail? Well, there are many reasons that they could fail. One of the reasons, and really the Addams family example has all of them. Um, One is that when plans become outdated, it's pretty rare for a plan to be so outdated that it's been the 1960s since they were last modified. But even a few years, even 10 years, 20 years can be too long for an estate plan update. Another reason estate plans fail is that assets are not coordinated with the documents. For example, in the Addams family, the husband in 2020 tried to go and create a trust, and he wanted to move assets into that trust. But he unfortunately did not realize that he owned his real estate equally with his wife. And there are some states in our country where you're not allowed to not allowed to give your half of the real estate to someone else who's not your spouse when you're both owners. That's called tenants by the entirety. So he violated that, and therefore this family has to unwind all those different transfers that he attempted to make because he violated state law. Another reason that estate plans can fail is when beneficiary designations override intentions. If you have a retirement account that gives everything to your ex-spouse, well, that's probably not what you wanted. You probably wanted it to go to your children after the divorce, but you forgot to change the beneficiary designation. I have a feeling many of you on this call have experienced that and seen that in your own practice. Another reason estate plans can fail is that tax laws and family dynamics change. This certainly happened with the Addams family as far as the dynamics changing. It was a lovely family in the 1960s, but 50 years later, it was already a disaster. Tax laws changed too. The estate tax was much different in the 1960s than it was in the 2020s. Another couple of reasons why estate plans can fail is that as if clients avoid having conversations with interested parties. That might mean conversations with their children, or it might just be conversations with each other. The Addams family failed in this way too. There was a lot of surprises that happened after they died, surprises to the children, and that will cause an estate plan to fail. And then lastly is when professional advisors fail to communicate with each other. That's a missed opportunity that can sometimes lead to estate planning failure. Maybe it's the lawyer creates a well-considered estate plan, but doesn't coordinate with the financial advisor about how to make sure that that plan is actually that the accounts are actually titled correctly to impact that plan. Let's get into the pitfalls. Pitfall number one is if there's no estate plan at all. Um, if you have no estate plan at all, these are the pitfalls of mistakes that are often made in estate planning. If you have no estate plan at all, I'm sure many of you know, then that means that state law will govern where your assets go at death. Every state has different laws about this. I'm in Georgia, and you are too. So in Georgia, we call it the intestate laws of Georgia, and those tell us where our assets go. For example, if the Addams family, if husband had died first, which is actually what happened, state law would have said that everything goes to his wife, but she could never get less than a third. So his four children would share the other two-thirds. That also would have been an estate planning failure in this family. Um, if you don't have an estate plan at all, you can guarantee that the court is going to be involved. because the probate court, to be specific, is the court system that enforces the intestate laws of Georgia. So that's the system that'll make sure that spouse and children share in the assets. Um, it also is the court will also be involved if you don't have an estate plan that considers incapacity. All right, a big part of estate planning is not just death, but also incapacity. What happens if you're alive, but you've lost the ability to make decisions, whether that's as a result of a brain injury or a disease like Alzheimer's. It all is the same as far as needing a plan. Typically, that's a power of attorney for financial decisions. It's a healthcare directive for healthcare decisions. But if you have no estate plan at all, we're imagining you don't have either of those documents. So then the court is definitely going to be involved in appointing a guardian to manage your healthcare decisions and a conservator to manage your financial decisions. And those two things, the guardian and conservator, are governed by the court system in Georgia. Another pitfall that occurs with no estate plan at all is um, or I mean, a cause of having no estate plan at all is if you've procrastinated and did not think that you needed an estate plan, either because you're too young or you don't want to deal with these issues. That tends to cause people to have no estate plan because they don't get around to putting it up as a priority. And here's what you can do. Here's what you can do as an advisor to your clients to help them avoid this pitfall of no estate plan. I might suggest that you ask your clients when you meet with them whether they have an estate plan in place. Do they have the documents that everyone needs at the very basic level, a will, a power of attorney, and an advance directive for healthcare? Those are the three key documents in Georgia. I strongly believe in, this is outside the scope of today's meeting, but I strongly believe in a trust to avoid probate as your key document, and that the will be more of a secondary document. But any collection of those would be an estate plan that could save a lot of headache for your clients. Another way you could help the client avoid this pitfall is to coordinate introductions to estate planning lawyers that maybe you have a connection with and that your other clients have used and liked, so that the client can go to somebody who can speak to them about the benefits of estate plans. Pitfall number 2, outdated documents. The Addams family is another perfect example of a family that has outdated documents. They set them up in 1965 and they never looked at them again until the 2020s. Um, that is a pitfall that I see frequently. I very often have clients who come to me for the first time and say, "We haven't looked at our documents since 20 years ago. Back then we had minor children. Back then we only had 2 children. Now we have 3 children. Back then our parents were going to be the executors of our estate. Well, our parents are now in their 80s, and it's not a good option anymore for them to do it." So much changes. Not only that, but tax laws change, and they can change materially. Um, for example, I'm sure everyone on this call is familiar with what the Secure Act did just a few years ago to modify how retirement accounts are handled at death. In particular, that there's a 10-year payout that is now impacting us, and so we need to consider whether our estate plans need to address that. Also, the estate tax, which right now doesn't impact so many of our clients. But think about this. In the year 2016, the estate tax exemption amount was $2 million per person. So as a married couple with 4 million or less, excuse me, 4 million or more, you're thinking about the estate tax, and you might be having a plan that considers that. Today, in 2026, the estate plan exemption is $15 million per person. So that's $30 million for a family, for a married couple. So there are so many families that don't need sophisticated estate tax planning under today's laws. Other changes that can happen with outdated documents are that there might have been life cycle changes, like um, you've had a divorce and now you've remarried and your family is now blended. You have children from your previous marriage and your spouse has children from their previous marriage. So do the documents account for that? Here's something you can do to help your clients with pitfall number 2. You should consider, maybe in your annual meetings or just whenever you're speaking with your clients, reminding them that they should probably review their estate plans when there's been some kind of circumstance change in their lives. For example, they've gotten married, they've gotten a divorce. I just talked to a client yesterday who recently married a spouse. They're in their 70s, and they each lost their prior spouse to, who died, and they've found each other and they've married. So they're talking to me about updating their estate plan. Other family cycle events are birth of children or grandchildren, and does that change how you wish to leave your plan in place? If there's been a fiduciary that's died, like I mentioned before, if your dad was going to be the main fiduciary of your estate, he was going to be your executor and your trustee and all these things. Well, if he's passed away, then is there someone next who you wish to serve in that role? Other major things are retirement, sale of your business, major increase in net worth. I had a client who amazingly informed me that, and this was a younger client, informed me that they had invested in cryptocurrency when it was heading straight up, and they suddenly had many more millions than they ever imagined that they would. That's the only client I've ever heard that say that, but I'll share it with you because it does happen. Um, or relocation to another state. I hear that very often from my clients. Many of them come to me when they move into Georgia. They used to live somewhere else for most of their adult life, but they've moved to Georgia to be closer to their grandchildren or for other reasons, and they want to know what to do about their estate plan. And then I tell my clients, and you can tell your clients this as well, that every 3 to 5 years, it's a good time to sit down and open up that estate plan. And that might mean sitting down with your estate planning attorney and having a conversation, let him or her be the one who guides you through it, because so many of our clients don't fully, comprehend all the details of an estate plan. Um, I also tell my clients, and you can tell yours, that every year, if you think about it, maybe just think about your estate plan for a moment. You don't have to get it out and open it up, but just think about it. Have there been changes? Has there anything occurred in our lives in the last year that might warrant changing the documents? Pitfall number 3, beneficiary designation mistakes. Most often, the beneficiary designation mistakes are related to retirement accounts. But I also am talking about life insurance, the other main resource that is governed by beneficiary designations. And this is where usually they're outdated too. They're outdated and they still name the divorced ex-spouse as the primary. And there's no law that says that if you name your ex, that she doesn't get it or he doesn't get it. There are laws that will protect your will from that mistake, but not beneficiary designations. Sometimes beneficiary designations name minor children to receive an asset. Okay, I have a client who he divorced his wife. They had one child actually, they had two children together. They had two children together. And then he died of a heart attack. He had updated his beneficiary designations to say that when he dies, he wants his retirement account to go to his two children. Well, that's perhaps better than going to his ex. But what he didn't understand was that those two children are too young to receive a retirement account. They were both under the age of 18. So for that client, I had to help them set up conservatorships in the probate court to manage the retirement accounts on behalf of those minor children. And that opened up a whole new level of complexity for this family. And unfortunately, it wasn't even that much money where it really was worth all the hassle. I mean, it was, but it's not a lot of money. It's a lot easier when it's millions and millions of dollars, but it wasn't the case for this family. Um, another beneficiary designation mistake that's a pitfall is not updating them frequently enough to know that you're outdated. I have another client who, when she died, we being the financial advisor and I realized that the beneficiary designation she had on her account was referencing a trust that was going to be created under a will that she had signed 30 years ago. But she had signed more recent wills before her death, even in the last few years before her death. And those new wills have different kinds of trusts set up in them. So we had an issue. She's trying to give everything to a trust that doesn't exist and never will. And so we had to work quite diligently with the financial institution to try and figure out what to do. And I think if we were to ask her, she would have said that the result was not what she wanted. It was not what she intended, but it was the result that we had to live with. What can you do with those beneficiary designation mistakes? Here's a few things you can do. I want you to look for common beneficiary errors when you're reviewing your financial plan with your clients. One is look and see if they name their estate as a beneficiary. I didn't mention that yet, but that is one that is often not the right result, particularly for retirement accounts. If the retirement account names the estate of Mark Brandenburg, and it's my retirement account, then the estate is going to have to withdraw that account in 5 years rather than 10 years. Whereas if the beneficiary designation had said that it names my spouse as the beneficiary, then as you know, my spouse can take it out over a much longer period of time. Look for beneficiary designations that treat their family differently. Are they giving 25% to one child and 75% to the other? That's not necessarily a mistake. Maybe that is what the client intended, but that might lead to a dispute where the 25% child feels that they got slighted, and why is that? And we want to try to avoid disputes in estate planning as well. I already mentioned the ex-spouse. I've already mentioned minor children. Again, I really strongly advise against naming minor children in beneficiary designations. Another option might be to name the custodian under UTMA for a minor child, or even better is to name a trust for that minor child to receive the beneficiary to receive the account. And then lastly on the slide here is special needs beneficiaries. If you know that this family has a special needs child or grandchild in the family, you want to make sure that that special needs child is not going to receive this account. It could kick them off their government benefits. So it's better to have the resources go to a special needs trust, sometimes called a supplemental needs trust, to make sure that it is properly used for things that supplement what the government provides and therefore does not kick that person off their benefits. Pitfall number 4, improper titling of assets. Where I see this the most, and you probably have too, is with revocable trusts. As we all know, revocable trusts are really useful tools to avoid probate. They're also sometimes called living trusts or revocable living trusts, whatever your preferred term is. They all work the same way. And as you probably know too, that it creates a bucket in which we can put assets in during your lifetime to avoid probate. But if you don't put assets in there, then they are going to be probate assets at your death. If you have a good estate plan, you'll also have a will that will catch those probate items and pour them into the trust after you die, but you didn't really avoid the probate process by using a will to do it. So Oftentimes we see clients who go to law firms or will mills and get a revocable trust, and then they don't fund it with assets, and so it doesn't really work to their advantage quite the same way. Another area where improper titling of assets can occur is jointly owning assets. Okay, many times two spouses will jointly own an asset. That's probably okay in most cases. But many times we then have let's say a widowed mother who decides that she needs help with someone paying her bills, and so she wants to put her child on the account with her. So now it's mom and child on the account as joint account holders. What is oftentimes forgotten or misunderstood in this scenario is that when mom dies, that child gets everything in that account immediately and it's all theirs. Okay, they don't share it with the other children in this family. Um, I've worked with some families where that's okay. The child who receives the account will just divide it up among the other children, and it's no big deal. They kind of do the right thing, is what they call it. Um, Other times, there's not much money in that account anyway, and so the surviving account holder will use it to pay the funeral bill and things like that. But I have seen circumstances where it's explosive. The amount of money in that account is significant, and the child who receives it is already getting or already has a reputation in the family of being too involved in mom's life. And now this child gets all this money that he doesn't have to share with the others. That's a real problem. Um, Another title, improper titling of assets example I have is um, when business interests are owned in the account. Or business interests have an account, like a business account. If the owner of that business dies and there's no partners, then who has access to that account? Um, if the owner had put his or her interest into a revocable trust, then it's very clear the trustee gets to step in and take over that account, including the other business assets. But if you didn't do that and you just got a sole owner of an account and he dies or she dies, then we have to wait for their will to be probated usually in order to get an account opened that belonged to the business. So that's definitely a problem I've seen. What can you do? You can confirm trust funding. If you hear or learn about your client doing a revocable trust, just confirm with them that they have funded it with the assets that they want it to hold during lifetime. Also, maybe you want to maintain updated asset inventories for your client, not just the assets that you manage, but all of their assets, so that we have a sense of what they own and how they're owned. Those are all key parts of an estate plan. Pitfall number 5, failure to plan for incapacity. Oftentimes when I get a new call or get a call from a new prospective client, they'll say something like my friend or my financial advisor or my son tells me that I need a will. So I'd like a will, please. First of all, I begin that conversation with helping them get educated that a will is maybe not the only document they need. But oftentimes when they're saying they need a will, they're thinking about death. But incapacity is a major part of estate planning. I had a client a number of years ago who had an operational business that was pretty successful, but he knew everything about that business and nobody else did. He knew where the skeletons were hidden, but nobody else knew. And he exercised that day and um, felt like he was losing his breath, and he had a heart attack. And they rushed him to the hospital, and he lived, but he was essentially in a coma for what ended up being several weeks. And he came out of it okay, so happy ending in the end. But during those several weeks, his business was supposed to be accepting payments from his customers, and he had bills to pay, and we couldn't get access to the account where the business was operated. We couldn't really find out what bank he had an account at. That took a while. Um, and a lot of this could have been avoided if he had a power of attorney. And that was the main challenge is he didn't even have a power of attorney. So it took a lot of effort to get there. Um, it's important to have a durable power of attorney. And as many of you may know, the state of Georgia has a form that we call the statutory form power of attorney. The Georgia General Assembly in 2018 created this form and put it into our statutes when they enacted a new set of laws that govern POAs. And that is a very simple document to find. It's not always that simple to complete without a lawyer's help, but it's intended to be easy. It's just not. And that's a very important part of an estate plan is having one of those. Another important part that is often forgotten is having a healthcare directive. The Georgia Advance Directive for Healthcare is also a statutory form. They just didn't use that name when they enacted it in 2007. They just call it the Georgia Advance Directive for Healthcare. But it is also a form that is in our statutes. And it's very important if a client of ours um, loses the ability to make healthcare decisions, either because of dementia or because of a brain injury, or they're under anesthesia and there's some decision that the doctor needs to make. That document also has some other key and useful things in there. What if the client is pregnant and is in a condition where they are either terminal or they're in a state of permanent unconsciousness? Those are the two conditions that we review. What if they're pregnant um, and they've selected that they want their death to occur naturally and not be kept alive unnecessarily long? Well, that was in the news not long ago. I think it was last year. I think it was last year. There was a young lady who was pregnant and was in a medicated coma, I believe. No, I think it was a coma, but I don't know if it was medicated. She couldn't come out of it, and the state of Georgia decided that she couldn't be allowed to die, that they were going to keep her alive longer so that the fetus could become viable. And her family, I think it was her family, argued uh, that she didn't want this, that she wouldn't have wanted this. But unfortunately, she did not express that clearly enough. And with this Georgia's laws on this matter, um, the hospital felt that they had to keep her alive to allow the fetus to survive. Another area of incapacity that impacts a lot of us is what to do with your digital assets, um, your online account, your access to your iPhone or to your any device you use, managing that. The Georgia statutory form power of attorney does allow the POA to have access to electronic communications and be able to access electronic devices. But this is becoming a new and developing problem where when we have more things like facial recognition and such, it just becomes a little more complicated to get access there. So there's a possibility for a pitfall there. The next pitfall is trusts that do not match client goals. All right, trusts are an important part of estate plans. And there are many different kinds of trusts. Some trusts are like the one I described earlier, the revocable trusts that help you avoid probate. Other trusts are what we call testamentary trusts, where they don't get created until after someone dies. And so it's embedded either in your will or in your revocable trust. That might be a trust for a child of the client who's not yet old enough either legally to manage money or just not yet mature enough with enough years of experience to manage money. There are also trusts that exist to hold assets for a surviving spouse, which could be because the client didn't want that spouse to have full access to the resources, or it could be solely for tax advantages to avoid to maximize the estate tax exemption. So there are lots of different kinds of trusts that exist. But we find, particularly if there hasn't been frequent review of an estate plan, that sometimes the trusts are too simple for a complex family situation. And that maybe they're resting and relying on a very simplistic estate plan that no longer matches the complexities that trust can help with. For example, maybe a parent is going to leave everything to their children, um, but that was back when they were minor children, and it says that the children are going to get everything when they turn 21 years old. But one of those children now is older than 21 and is struggling with drug abuse. Um, Okay, so that child would not be an appropriate person to get money outright. And so we might have wanted a more sophisticated trust plan for that particular child that goes maybe for their lifetime. And maybe it has provisions in there that reward him if he's clean and can restrict access and use of the money if he's not. Another pitfall with trusts not matching client goals is overly complex planning. And I'm seeing this more and more in the last few years, where some of my retiree clients are coming to me for the first time, and they are showing me documents that they did 20 years ago from another estate planner who's most likely retired now. And back then, 20 years ago, this was a perfect plan, and it did have the complexity it needed, mostly to maximize the estate tax exemption. But that was, when the estate tax exemption was $2 million per person. Now it's 15 million per person. Do we really need so many trusts and complex planning as part of the overall when this client has $4 million, not $30 million as a married couple? And there's really no need for some of that other planning. Um, another example has to do with poor trustee selections. So with a trust that does not match client goals, it might be that they have a trustee who no longer really fits with the kind of trustee that they want today. So let's talk about that. And you can be a big part of that conversation as well, is who should be the trustee of a trust? I tell my clients this frequently, and you can see it on the screen as well. You can talk to your clients about it. Um, a good trustee is somebody who has financial competency, is emotionally and financially mature. Um, Oftentimes, if we have two of the same options, I might choose the one who's geographically closer to the client, but that's not a necessary thing. Um, I think that a trustee is someone who can manage family dynamics and who can also manage professional advisors, because they're going to likely have to work with a lawyer, a financial advisor, an accountant, maybe a real estate agent. And then also a trustee has to be willing to do the work and be available and have the time commitment to do it. It's a big job to be a fiduciary, whether it's a trustee or an executor or a power or an attorney, in fact, under a power of attorney. Those are all big jobs. And so it does take time and it takes willingness. And many will do it out of love for their family member. But there are also many families who are now looking for outside professional fiduciaries rather than a family member. And they go to trust companies and other professionals who are willing to do it for them. Pitfall number 7 would be the estate tax and exposure to it. As I already shared with you a few minutes ago, the federal estate tax is quite high. The exemption is quite high right now. As a single person, you're allowed to die with $15 million until you're taxed. And if you're married, you're allowed to double that to $30 million before there's a tax. So if you die with 30 million or less and you were married, no tax. If you die with, let's say, 31 million, then that 1 million extra gets taxed at 40%. This is all, of course, talking big picture here, but 40%, which would be a $400,000 tax. Um, so for those who are very wealthy, it is still a significant tax. I mean, if you're $10 million over, it's a $4 million tax. So that's a lot of money. And there are still wealthy families who are doing a lot of hoop jumping to try to minimize that. So it's important to be aware of it. It's true that most of my clients don't fall into this category, and most of them don't have the estate tax issues to worry about anymore. But there are some, and there's some other estate planning law firms in town who have maybe a core competency in the wealthiest members of our community. Um, it's just a good idea to keep an eye on it. Right now, the law is permanent. But that can be changed at any time by Congress. But we went through a couple decades where it was not permanent over the last couple decades, and it kept moving and changing. Right now, it's $15 million per person. It will adjust with inflation, but that's it. And we'll see where it goes. So it's something to keep an eye on for everybody. Um, and this is where you can also be helpful if in this regard. If you know that a client has had a serious appreciation of wealth, then it would be a good time to talk with them about meeting with a lawyer to discuss options. Um, I've seen businesses that have grown from being worth $1 million to being worth $20 million, seemingly overnight based on things going on with the business. Um, that cryptocurrency client I mentioned experienced something like that. So it's a good idea to keep an eye on this if we're talking about very wealthy clients. Pitfall number 8, business succession failures. Um, when I think of this pitfall, I think of the TV show Succession that was on HBO a number of years back. If you're listening to this and you haven't seen that show, I'll tell you that it is about a patriarch who has run a international media conglomerate. And it's always been a family business. And he has adult children. He has 4 adult children. And he's brought them into the business and has groomed them to try to get ready for succession. However, the patriarch is a real asshole, and he's an asshole to his children and to everyone else around him. And he has completely messed up the succession of his business. Um, but the show centers around all the different machinations of his children conspiring with each other against their other siblings and trying to take the business from their dad because they feel like he's not competent anymore, and he's fighting back from them. It's a complete mess. Very entertaining, but also does happen in real life, just usually at a lower level. But we deal with it probably at a lower level um, client. So any family business has to wrestle with succession when the first generation is ready to pass it on. And that is a good time to meet with a lawyer and meet with you and meet with their other advisors to talk about how to successfully pass on the business over the course of a period of time. This is not something that's generally done in the last year before retirement. It usually is done years and years, maybe even 7 to 10 years before retirement of the first generation. I also I had a client recently who is discussing succession and has brought his son into the business for many years. And the son has actually grown the business 3 times what it was when dad was managing it alone. But dad has some other children as well, and he was wanting to put in his estate plan that when he dies, he wants a small percentage to go to his other children who have never been in the business, and the largest percentage to go to his one son who has been. And his one son expressed concern about that and said, Dad, I'm the one who's been building all this. I'm the one who knows the business. I should get 100% of it. And all your other assets should be divided equally among the children. Um, and the dad was resistant to that. And I also helped him think about the possibility of the complexity of having children with small percentages who are still involved in the business, at least from a financial interest, but aren't actually making decisions. It just felt like it could be a recipe for a family dispute. Pitfall number 9. Here we go. Poor communication with heirs. The Succession TV show was another excellent example of poor communication with family and with heirs. Um, I I talk with my clients about something called an ethical will. An ethical will really is a misnomer, but it's the name we have for it, and it's a letter or some other expression of wishes that you can leave to your family. So if you didn't feel like you had the words to or the time to speak to your family directly about your estate plan, this is a message that you leave behind. The idea of it is that it's a warm, lovely message that speaks truth to your family about what decisions you made and why you made them. Um, you could say something like, anyway, I don't need to give you an example, but that is a way to leave a communication to your heirs that can help them understand your estate plan. What might be even better is actually having the discussion with them now, especially if we're talking about a client who is advanced in age and the children are all mature and get along pretty well together, and you can have a family meeting like is shown on the slide here, where you just talk through this is what to expect. Hey, family, I've selected the oldest child to be my executor, not because I love him more than the others, but because he's a um, financial advisor and he knows how to work with professionals and he knows how to manage all the details. And you other two children, um, who I love equally don't live in the same region of the country and don't have the same skill set, and so that's why I've chosen that person. Anyway, those kinds of conversations can do a lot to prevent surprises. If we want to have a family that argues or has bad feelings about an estate plan, just leave a bunch of surprises for them that explode upon your death. Here you go. Here's my estate plan. Boom. Well, that results in some nasty family arguments. Pitfall number 10 is lack of advisor coordination. I feel strongly about this, and I bet you do too, otherwise you wouldn't be on this call, that it is important for a client to have a team of advisors. I think the three legs of the stool should be the estate planning lawyer, the financial advisor, and the accountant. Um, and as best they can, those three should coordinate with each other and at least connect. And when I do an estate plan, if I know my client has a financial advisor, I will send a copy of the estate plan to the advisor with my client's permission, of course. Um, and I will connect with the financial advisor and make sure that if we just set up a revocable trust, that they know what the strategy is so they can help the client to retitle accounts and change beneficiary designations and so forth. And I just think it's not necessarily the client's mistake if there's lack of coordination. It's more a missed opportunity to catch something that the client's doing wrong, or to just make sure that we are giving the best service to our clients that we can. All right. So red flags for you to watch for with estate plans. One is no documents or outdated documents. That's a real red flag that you should raise that with your client and maybe help them find an estate planning lawyer. Another is they just had a recent marriage. Usually, it's probably not your client's first marriage. If we're talking about this, it might be a second marriage. Certainly, a divorce is an important time to review an estate plan. and something major financially like a business sale. Another red flag is if your client comes to you and discusses special needs beneficiaries, you should make sure that the right kind of estate plan is in place so that beneficiary doesn't lose their government benefits. And then lastly are families that already have conflict or are ripe for conflict. And a ripe conflict would be a blended family. You know, dad dad divorces mom and then marries a new lady, and the adult children hate the new lady. But dad wants to leave everything to the new lady upon his death so that she can continue living the customary lifestyle for the rest of her life. That's not necessarily a bad plan, but that's a kind of plan that leads to family dynamics being challenging. Good time to bring that up with your clients if you see that. All right, I'm going to end with these three key takeaways that I'd like you to take away from this meeting. And then if we have a few minutes remaining, I'll take Q&A. One takeaway is that most estate planning failures stem from poor coordination and outdated planning. So it's just a matter of having the conversations with our clients about, hey, does your estate plan still work the way you want it to? How long has it been since you looked at it? Number two is that financial advisors are in a great position to identify risks before they become legal or family problems. You are likely meeting with your client at least once a year, maybe more than that, and they really trust you and they really value your expertise. Estate planning lawyers like me, sometimes it can be many years between hearing from a client, and we don't have quite the same bond that you have with yours. And then number three is ongoing reviews and professional collaboration. I really think they improve client outcomes, and it's a big part of my practice is to try to work with other professionals for our clients. All right, great. I'm going to stop sharing my screen so I can, because I don't need the slideshow anymore, and I can do it right. I'm going to look to the Q&A. Just give me a moment while I peek into there. Okay. Oh, good. There are a couple of questions, and I will take them. And please add more if you like. One question is it best to name a custodian in an IRA beneficiary account for a beneficiary that is under the legal age of majority? Thank you for that good question. I think it is. I think the answer is yes. I really do not want to see clients naming minor children as beneficiaries. When I've had to help situations like that, and we set up a conservatorship for those minor children, you're involving the court system and you're creating a dynamic where the minor has a conservator until they're 18 years old, and then they're handed the money at 18. So I try and come up with any way to avoid that. The most basic way is to say that you want to leave it to a custodian for the minor child and put that in the beneficiary designation. A little more advanced way is to name a trust, like the revocable trust is the beneficiary if you have no spouse. You would say the revocable trust is the beneficiary, and then the revocable trust has all the details about what happens to minor children and how they receive their assets. If you're going to rely on a trust, you just want to make sure your lawyer has thought through this and has the right retirement account provisions in the trust so that the retirement account, excuse me, so that the trust is considered a beneficiary under the retirement laws. Next question. Can I talk more about titling businesses in the name of a trust? I'd be happy to do that. Most commonly, this would be with a sole owner of, let's say, an LLC, single member LLC. What I do with my clients who have decided they want to avoid probate is that we set up a revocable trust and then we assign the ownership of the LLC to the trust. So, Mark Brandenburg is the owner of the LLC. Mark Brandenburg signs an assignment document that's a private document. It doesn't need to be reported to the Secretary of State. They just don't need to know. They don't care either. And it says that I assign my interest in the LLC to the Mark Brandenburg Revocable Trust. And that way we have that document to prove that now the trust is the owner, so that if we have to show the bank who is the beneficial owner of this business after Mark Brandenburg dies or becomes incapacitated. We can show them it's the trust and that the trustee will step up and take over. So that's how I do it. There are, um, yeah, I lost my train of thought, but that's how I do it. Let's see if there's any more questions. Uh, Looks like I'm not seeing any more questions.
Hey,
Let me just
Mark,
look at,
we actually had one come into the chat that I
thank you.
popped over to you. Do you see that now?
I'm looking at the chat right now. Let me see. Okay, is it one alternative to naming minor children is to name UTMA? Can you explain how this works, trade-offs relative to setting up and naming a trust as beneficiary?
Yes, sir.
Um,
And then one more too after you finish. Thank you.
okay, okay. Um, uh, Again, I think the lowest hanging fruit is just to say that you want the beneficiary to be the custodian for the minor child. It's really up to the financial institutions whether they'll accept that, and that's really more your, you have a stronger connection to the Charles Schwabs and the Fidelities and so forth, and their legal departments. I've never seen it fail, so I like to say that as a low-hanging fruit for my clients. But I prefer my clients have a much more a considerated estate plan where a trust is a big part of that. And if even if a will is their primary estate planning document and not a revocable trust, then I might say to the client, okay, name your spouse as your first beneficiary under the retirement account. And instead of naming your children, then in that case, name the trust that the will set up at your death for the children. We sometimes call that a management trust or it's a testamentary trust that's created for the children until they're a certain age, usually. The next question is, actually, I'm not sure what the next question is. Kathy, if you can help me find another question, please read it out to me and I'll be happy to answer it.
Sure. It's just, are there estate planning options for blended families?
Thank you. Are there estate planning options for blended families? Yes, there are. And it's, first of all, or I'll say it's most common that a spouse, when they die, will leave everything to the surviving spouse in a trust. In a trust. Sometimes these have fancy names like Q-tip trust, if you've heard that before. But it's really a trust that is not about taxes, which is what the Q-tip is based on, but it's about protection. So let's imagine husband dies first, and let's imagine he's wealthy enough that this matters. He's going to leave everything to his surviving spouse. She is not the mother of his children. The trust that is baked into that estate plan says that the surviving spouse can use the money for health, education, maintenance, and support for the rest of their lives. But when the surviving spouse dies, when she no longer needs the money, then the money will revert back to the husband's children. So he's making sure that he's supporting his wife for the rest of her life, but any money that's not used goes back to his children, not to his wife's future spouse or his wife's children. That's our most common approach. There are other things you can tweak to that plan, but that's a very good way of doing it. All right, I think that might be it, Kathy.
Wonderful. Mark, thank you so much for sharing such insight and wonderful perspectives today, important perspectives. And a big thank you to everyone who joined us. We truly appreciate your time and engagement. Be on the lookout for a follow-up email with a replay link, the PowerPoint deck, and a brief survey. Your feedback helps us continue to deliver meaningful experiences. Thanks so much, Mark, again. Wishing
Thank
everybody a
you.
wonderful afternoon and a great holiday weekend ahead.
Bye-bye.
Bye-bye. Thank you.